So your client has a deposition just around the corner and it's your job to prepare them. But what do you do? What do you say? Well, in this video, I'm gonna share with you the 12 do's and don'ts of depositions that I give to my clients so they can knock it out of the park. Welcome to Law Venture. My name's Jarrett Stone. I'm the owner of Stone Firm PLC, and it's my job today to talk about depositions. But before we dive into the content of this video, I do want to get oriented a little bit here, because if you're prepping for a deposition, that means a lawsuit has been filed and you're in the discovery process, prepping for a potential trial. And because of that, I do recommend that you go in the description down below and you click the link to Trial Ad Academy. Check that out. That's an online course devoted to giving you the skills necessary to go conquer the courtroom. I strongly and highly recommend always that from the very beginning of accepting a case, or as early as possible, you start trying to formulate what your closing argument is going to be at trial. In other words, you should always reverse engineer your case by starting with your closing argument first, because if you can anticipate the arguments and the points that you want to make, then you know exactly the evidence you need in order to make those points. And then if you know the evidence that you need, then you can start trying to get that evidence during discovery, like through depositions. And I also recommend that you reverse engineer the other side's closing arguments, because if you can anticipate the arguments they want to make, then maybe you can head off those arguments during discovery to where you can find particular pieces of evidence or testimony to just squash those arguments from the very beginning. And the more arguments and points you can take away from the other side, the more likely your case is going to prevail. So with all that said, be sure to check out the link to Trial Ad Academy down below. Now, let's get into the content of this video by starting with the first tip. Don't stress about it. That's the first thing that I tell my clients, because most of them have never had their deposition taken, and so they default to just assuming it's going to be this aggressive, contentious experience to where it's just going to be a horrible experience altogether. And I think that comes from some natural default to assuming that it's going to be like what they see on TV, like what they see on Suits, or maybe what they see on YouTube as well.
Wait just a second. Come over here. Hold it. Hey, wait a minute. Hold on. Come over here. No way.
Yeah, it's probably not going to be like that. So whenever I talk to my clients, I try to stress the point that they should not stress. And the reason why I do this is because I want them to get a good night's sleep before. I don't want them losing any sleep over the next day's deposition. And I want them to bring their A game, because depositions can sometimes be long, it can sometimes be draining. The last thing you want is a long and draining deposition after not getting a good night's sleep before. And so if I can alleviate that stress in advance, then I always think that's gonna be beneficial to my client. And one weird trick that seemingly works in my situation, which you're more than welcome to use, is that I'll convey my point to the client by explaining, I'm not going to be suited up for this deposition. If it's an in-person deposition, then I'll probably be business casual at best. If it's a deposition over Zoom, then I'll probably have like a nice shirt on. And the point here is that typically clients can be intimidated by people in suits, even if it's a mediation. I've had the client say that the mediator, who's a neutral party who's wearing a suit, was intimidating because they were wearing a suit. And so by showing that I'm not going to be suited up, that helps kind of confirm this idea that this isn't going to be the super, contentious environment, and allows the person and the client to ease up a little bit. Psst, hit that like button down below and don't forget to subscribe. Now this takes me to the second tip. Do assume that the jury is going to see and hear the deposition. This means a couple things. One, I want my client to dress appropriately. I don't want them wearing like a tank top or something. And two, I want my client to be courteous and just assume that this video footage or any type of audio recording may be shown to the jury. Because the last thing I would want is for my client to be a jerk during the deposition and try and have this fake niceness going on during trial, and then the deposition end up being shown during trial. Then you kind of have this Jekyll and Hyde situation, and then the credibility of my client just plummets. That's not good. This means that if the person who's asking questions to my client kind of has that sassy attitude that isn't very appealing, or is asking stupid questions, then I need my client's tone and just body language and just overall presentation to remain calm, remain polite, remain professional, despite all of that, which can be easier said than done. But if my client can do that, then we don't risk hurting the case at all if the audio and or video is shown to the jury. Do take breaks. I tell my clients all the time that if you need to take a break, then feel free to ask. The only caveat is that my client needs to make sure that they answer the question that was asked before asking to take a break. So basically, question, answer, ask for break. The reason for that is it's frowned upon and it looks really suspicious if a question is asked and then you say, well, can I take a break real quick? And then the break happens and then you come back and then you answer the question. Just doesn't look good. But there are probably two main reasons why breaks are fantastic ideas. First, it allows the client to become a little bit more centered. After asking questions for however long, you can kind of get a little jumbled in your mind about what's going on, what you're answering. And so I tell the client, okay, ask for a break, get centered, stretch your legs. Also put a little bit of extra juice in your battery because depositions can be super draining. And then it also gives me, and this is the second benefit, the opportunity to talk to the client about maybe clarifying some of the questions that they may have been confused on, to where once they are back on the record during the deposition, they have that opportunity to have that clarification put on the record. Or it allows me to have the opportunity to talk to the client and say, hey, this is where I think the deposition questions are going, and here's kind of the best way we can address these. And then that allows the strategy to kind of unfold a little bit for the client to where they feel a whole lot more confident after the break. Do pause between answering the question. And this can be a little unorthodox because whenever we hear a question, we're used to answering it immediately. In fact, you'll be surprised how often, and you may not even notice this, you're answering questions before the question is even completely asked. But by waiting until the question is asked to pause and then answer, I tell my clients that one, this is gonna make sure that they understand the question in its entirety. Two, it gives me the opportunity to make an objection if I need to make it. And three, it also gives the client the opportunity to think about their answer to make sure that the answer that they're saying is the best answer they can get. Now, this naturally takes me to a super important point. Don't guess. And I can't stress this to my clients enough, that I don't want them to speculate on their answers. We're so used and trained to take a test and we have the options of putting A, B, or C, or maybe it's a fill in the blank, and we are trained to put something down in the hopes to maybe get some points towards our overall grade. With a deposition, with a lawsuit, that is not how it works. The last thing I want is for my client to speculate or guess, and in doing so, they unknowingly are guessing the wrong answer, and that ends up hurting them more than simply saying, I don't know. I can't overstate the importance of making this abundantly clear to your clients, that they are only obligated to testify on topics that they have firsthand knowledge on. And this is tricky because you'll be surprised how often people start kind of feeling bad whenever they're being asked questions and they just don't know the answer to, because they don't have that firsthand experience that leads them to that answer. So they start saying, I don't know, I don't know. And then at some point they start thinking, well, maybe I should know it. And then maybe I can start putting these pieces together in order to reach the conclusion, in order to maybe guess and speculate. No, I don't want my client guessing or speculating at any point. That's not their job. And so I always try and hit home the fact that if you don't know, that's okay. Just talk about what you have knowledge on, and then we'll go from there. But, and yes, there's a but, make sure that the client doesn't default to the I don't knows just out of a comfort of avoiding talking about certain pressure points on their case. Sometimes certain topics the client can recognize isn't good for their case, and so they're afraid to talk about those facts. Then all of a sudden, the client starts defaulting on the I don't knows, or the client starts trying to have selective memory. And in that situation, that's actually maybe more harmful than beneficial. And so it's your job as the lawyer to prep your client in advance of the deposition on what you're anticipating being those pressure points for your client's case, and talking through that process with your client so your client knows how to answer those questions in advance, to where sometimes it's just a matter of the client formulating the thoughts a little bit clearer than maybe what the client's feeling. And so if you can address that before the deposition, the client will hopefully give those answers to where, again, you're not feeding the answers, but you're helping cultivate those answers a little bit, because sometimes the client just simply can't clearly articulate what they're trying to say, and they may default to the I don't knows because they're afraid of saying it the wrong way. That's a little bit of a rant, but the point here is that you don't want the client to have this selective memory to where they come off as like they're hiding facts, they're hiding the truth, and then that ultimately hurts their case when it's presented to the jury. Don't make objections, leave that to me, your lawyer. I've had a couple clients try and make objections during the deposition on their own to where they say, I don't think I have to answer that because that's just not relevant. And then it gets awkward and there's some tension in the room. Then I have to explain to the client that they should answer it given the question that's asked in the situation. So I've learned to head that issue off, that situation off, by telling the client in advance that I'm the one who makes the objections, and typically what ends up happening is that there's a lower threshold for what can be brought up in a deposition than what can be brought into a jury trial. And so just because something's brought into a deposition, that doesn't automatically mean that it can be presented to the jury. We want to assume that that's the case in order to be safe, in order to be cautious, but the threshold is lower during a deposition. And so if there's an objection to be made, trust me, I will not hesitate to make it. I will not hesitate to go to bat for you. If something is improper, I will not hesitate to shut a question down. But if you don't hear anything from me, then that takes me to the next tip. Don't panic if I'm not objecting. I've had a client during a break say, is this going well? Because I'm answering all these questions and you haven't been objecting, and I'm agreeing with what this person's saying. I keep saying yes, yes, yes. Is that okay? And in reality, all the yes, yes, yeses were really non-issues. And so the client was afraid that by saying yes to everything that was being asked, that somehow her case was slipping away a little bit. In reality, I said, no, everything's going fine. Those questions, I'm not really concerned about them, and there really isn't anything to object to. And so just because I'm being silent, that doesn't mean the case is just going down the toilet. And so that was a little comforting for her to know. And so after hearing that little tidbit, I've now incorporated that in my advice moving forward when it comes to prepping my clients for their deposition. Do listen to my objections, because if I make a speaking objection, then I want my clients to listen very intently on what I'm saying. Don't just tune me out because of the lawyer speak that's going on. For example, if I make an objection and end up explaining that I'm making my objection based on the fact that my client would be speculating and doesn't have personal knowledge on the answer, then I would most likely want my client to answer, I don't know. Just a quick caveat, make sure you are familiar with how the rules work in your jurisdiction when it comes to objecting in a deposition, because those objections may differ from the rules involving objections in the courtroom at trial. For example, in Texas, if I'm in trial, I may make the objection. Objection calls for speculation. But in a deposition, it's a little bit different to where I'm more often than not making the objection form. Speaking of objections, I do recommend that you check out, and I haven't done that in a minute, the trial objections cheat sheet that I have down below. It's free, it's super easy to get. There are over 2,000 downloads of the cheat sheet. That's incredible. Okay, so let's move on. Do ask for any type of clarification or rephrasing of a question that doesn't really make sense. Look, I'll be the first person to admit that more often than not, my mind is probably going faster than my mouth, so not everything I end up asking and saying ends up making sense. As a Law Venture viewer, you probably understand that from watching these videos. And so I always tell my client that if they end up hearing a question that they aren't fully understanding, then it is perfectly okay for them to ask for the question to be maybe restated or rephrased. That way they're on the same page as the person asking the question, and they know that their answer is answering the question that's asked. Do be short, sweet, and concise in your answers. This one is huge. I tell my clients, look, if somebody asks you what time it is, there's no need to talk about the watch that you're looking at, the story behind the watch, or the freckle that's over nearby your watch as well. Because each one of those facts may lead to more questions, and each one of those questions may lead to more questions on top of that. And that's how you can have a very long and draining deposition. And I give the same story every time to my clients. I had a husband and wife combo client package who were injured in the same exact situation. They had the same series of questions that were going to be asked to them. The husband, he liked to talk and he wasn't really good with the short, sweet, and concise answers. The wife, she was a lawyer. She was short, sweet, and concise. The husband's deposition took probably 2.5 hours longer than the wife's deposition because he kept adding in extra details, which led to extra questions, which led to extra answers, which led to Don't be too short. And this one's tricky because I have to tell my clients in advance the potential issues with their case that I think the other side is going to try and exploit or maybe blow out of proportion. And so I explained to the client that if you end up answering yes to something like this, also be sure to explain why the answer is yes, to put it in context. So by adding the additional information and putting things into context, the client can hopefully head off the potential of the other side taking that yes out of context. Don't lie. I know it's obvious, but I need to stress this point to my clients because the last thing I want is conflicting statements. So I explained to the client that the oath that they're going to take on the day of their deposition is the same oath that they're going to take in front of the jury, which is to tell the truth and nothing but the truth. And so the last thing I want is conflicting statements on deposition day and trial day. And so in order to head that off completely, I explained that they need to say the truth and nothing but the truth. Okay, so these are the foundational do's and don'ts that I give to all of my clients, no matter the case specifics. But that also takes me to maybe a bonus tip here, which is to also go over some of the case specifics, some of the topics that you think are going to be discussed during the deposition. That way the client and yourself can be prepared for any pressure points that may be applied. And again, the best way to do that is to anticipate your closing argument and the other side's closing argument so that you know what's going to be the strength, what's going to be the weakness, and you can plan accordingly. Keeping with the theme of do's and don'ts, do hit the like button, do subscribe, and if you have do's and don'ts of your own that you think will benefit others, do leave those in the comments down below. Don't hold out on us. And when it comes to you maybe checking out future law venture videos, I hope you do.